Welcome. Today we are going to talk about insurance and also about the management of risks in an association. And as with some of these other topics, we are at the same time trying to talk about the kinds of assets that associations have. Insurance happens to be one of the most important sources of revenue for developments in particular situations. And just to recap, as you understand, most associations have only one real source of income, one regular source, which is the assessments that the members pay every month. And as we've talked about, some associations might have a small amount of investment income, but and very few have anything else. And so, if there is an unexpected loss, insurance becomes critical. Few associations are actually prepared to handle losses like this, that is, to pay for them out of association funds. Because by definition, an unexpected loss would be one that they did not budget for in advance, and one that, although they might have a small contingency fund, that's always possible. And where the reserve funds are set aside for anticipated repair and replacement of major building components. But if there's a sudden and unexpected loss, insurance becomes absolutely critical. And in most cases, it is their only safety net. So you need to understand how this all works. So let's talk about what insurance is. The first thing is to understand that insurance is a contract. That is, it's a piece of paper, a written document that provides for a deal between the insured and the insurance company. And I say this even though it may seem obvious, because many people seem to think that insurance sort of covers everything, and it's just not the way it works. It covers what's in the policy, and it has to be read and understood either by the lawyer, the directors, the property managers. Someone has to understand what's in the policy. So it's a contract under which the insured pays premiums to the insurance company, and the insurance company then agrees to pay for losses that are caused by certain perils or risks. In the event that the insured suffers a loss that is due to a covered peril or a covered risk under the policy, then the insurance company pays the costs associated with that loss. So that all sounds good, except that you have to understand that insurance policies cover some losses but not others. And this is where we get into some key terms here. Insurance policies have exclusions. Exclusions are risks that are specifically not insured against, not covered under the policy. That is, there'll be an exclusion that says this policy does not cover loss due to, and it might say earth movement, land rising or falling, or shifting, or flood, etc. Now, the way the policies describe what is covered and what is not covered can vary. There are two main kinds of policies. One is what are called named peril policies, and the other are called all risk of loss policies, or all risk policies, which are now referred to often as special form policies. But a named peril policy only covers what is specified. Now, for example, fire insurance or flood insurance or earthquake insurance. These are named peril policies. They cover loss only if it is caused by the peril that is named in the policy. Nothing else is covered. Other policies, and this is the type of liability insurance that associations are supposed to buy, and property insurance, is called all risk policies or special form policies. They cover all risks of loss except those that are excluded by the terms of the policy. So a CGL, or comprehensive general liability policy, or for that matter, a property insurance policy, you want to get policies that give you the broadest coverage. Named peril policies mean, the adjuster will look to see if it's a flood policy. If the damage was caused by anything other than flood, it is not covered at all. There is no payment. A key point here, insurance covers against what they call sudden and unexpected losses. Insurance normally does not cover damage that is caused by wear and tear or gradual wearing out of building components. It does not cover deferred maintenance or lack of maintenance of building components. It does not also, in most cases, policies don't cover damage that is caused intentionally by the insured. Not negligently, but intentionally. So, for example, let's say you have an association comprehensive general liability policy. Let's say the directors run up and punch somebody in the nose, and they get sued for assault. That's an intentional act. Look at the policy very carefully. You may find that it's not covered. They won't even. And by the way, policies often they include two duties. One is the duty, in the case of liability policies, the duty to defend and the duty to indemnify. The duty to defend is broader than the duty to indemnify, meaning insurance policies, the companies will typically, in the case of a punch in the nose or something that they think is probably not covered, they will probably defend the claim, although they may not pay it. And we'll talk about a little bit about how that works later in this presentation. The other thing to understand is that insurance coverage always has dollar limits. Everybody knows this. You've looked at your auto policy, etc. You understand that different coverages have different dollar limits. We refer to those as policy limits. And they also come with deductibles. And the deductibles are the amount that the association would pay out of its own pocket for any claim. And if the claim comes in under the deductible, it's less than the deductible, then the association pays for the whole thing. Now, let's talk about coverage disputes and the way that policies are interpreted. It is not uncommon that the association and their insurance company, the adjuster who comes out to deal with a loss, may disagree. There can be many things they disagree about. For example, they might disagree about whether the loss is covered based upon how the loss was caused. There may be a factual dispute over how the loss occurred. And for example, and this happens in a lot in the West, and it happens in really any place after there's a lot of rain. When you have years where it's very wet, a lot of rain falls during the winter or whatever, in the spring, there'll be a lot of property damage that is related to water. And water can do many things. Water might come through a hole in the roof and go inside and damage property on the inside. Water might also get under a house, particularly if it doesn't have a basement, might get under the slab. Once it's under the slab, or you might get into a basement for that matter, but once it's under the slab, once it's into a basement, it causes all kinds of damages on the inside. It could cause mold. It could cause, if it's under a slab, it can cause soils to expand. And the soils can expand, particularly if they have a lot of clay in them, they can expand and they can crack the slab or they can crack the foundation. Now, these are complicated losses because they did not happen in a simple one-step manner. It's not like there was a flood and it went into the house. There was rainfall, there was water, it went under the slab, it then affected the earth rose and caused the damage. It's a chain of causation. And there can be disputes over whether the cause is a covered peril or not. Was it water? Was it earth movement? Was it human negligence? Maybe human negligence is a covered peril, but water damage is not. And so it's easy for factual disputes to end up, and there's been a lot of litigation over how to resolve these disputes, but they can happen. For example, if an ice dam could form inside a soffit, and then it could cause the soffit to collapse. Well, okay, what caused that? Was the damage caused by water, or was it caused by, let's say, a squirrel, eating a hole in a flashing someplace and allowing the water to intrude? So you see, in the assessment of the adjustment of the loss, there can be factual disputes over what caused what. Now, the first thing that insurance companies do when they feel that there might be a coverage issue, the first thing they typically do, rather than deny it flat out, although sometimes that's so apparent they just deny it immediately, but more often than not, they will send out what's called a reservation of rights letter to the association or their attorney. And the reservation of rights letter will say, we're still investigating this. We haven't made up our mind yet. But we think it's possible that this loss might not be covered. So if it's a liability claim, and again, I'm going to talk a bit more about this, but they might go ahead and defend the claim, but tell you all the way, if we have to pay a huge judgment, we may not be willing to pay it because we're not sure this is covered. And we're going to conclude at some point whether it is covered or isn't, but in the meantime, we're not sure. So that's a reservation of rights letter. The next thing they might do, the insurance company might do, if they think a loss is not covered, is they may, instead of flat out denying it, they may file a declaratory judgment action in which they're basically asking a judge to tell them whether it's covered or not. And so they file they request a judgment that it is not covered. But in a sense, they're putting it in the hands of a judge, because if the judge comes back and says, yeah, no, this is covered, then they're going to pay it. Now, so one type of insurance litigation that associations can end up in is obviously declaratory judgment actions. If a claim is denied flat out, eventually, then it is possible that the association might sue for breach of contract for bad faith handling of the claim. Now, these actions can sometimes be, in many states, these things involve punitive damages, potentially. They can be high stakes litigation. And so you always have to keep this in mind. That is a hammer that is over the head of the insurance company. So they need to be careful about the way they handle the claim and whatever coverage decision they make, so that they don't run afoul of a bad faith action. Now, also, remember, insurance is a contract. The standard rules of contract interpretation apply to insurance policies. And this is very important in one particular way. There is a rule, as you're probably all aware, in contract interpretation called contra proferentum, which means that ambiguous language in a contract is to be interpreted against the party that put that language in the contract. And in other words, ambiguous terms in an insurance policy are interpreted against the drafter, meaning in favor of finding coverage. Now, there is a bit of uncertainty in the law as to how you figure out whether there is an ambiguity and how to resolve an ambiguity. So, for example, and I think in most cases, extrinsic evidence is admitted. But again, this is a disputed area of law to try to resolve the ambiguity. In other words, is there really an ambiguity? So, for example, a court might admit evidence of communications between the insurance company and their representative, the association director or president or their lawyer or something. What were the communications before they entered into the contract, before deciding as a matter of law to resolve the ambiguity? Because if there's an ambiguity, it'll be resolved against the insurance company. But is there an ambiguity? So sometimes extrinsic evidence is admitted, but that's a contested area of law. So there are certain terms that are potentially ambiguous, but understand that standard policies like the comprehensive general liability policies and standard property insurance policies, most of the terms, virtually all the potentially ambiguous terms, have already been litigated. So it's unlikely to happen, but it can occur. So be aware of the possibility of uncertainty. Associations need to buy three types of insurance. And actually it's four different types of coverage. Number one, they need to have first-party insurance. First party means, in this case, property insurance. It covers the association's property. The association is the first party, the insurance company is the second party. So first party insurance is, in this case, property insurance. It pays to repair the property in the event of loss that occurs due to a covered peril. Other type of insurance they have to get is third-party insurance. And third parties are not parties of the contract. So the first party is the association, second party is the insurance company. The third party is someone who got injured on association property or got injured by the association. This is liability insurance. Third party is liability. It pays a third party, does not pay the insured. However, it also covers the cost of defending the association against that claim. This is very important coverage because, again, as I said, the duty to defend is broader than the duty to indemnify. They will defend if they think there's any possibility that it's covered, even if they think ultimately they're going to deny the claim. Because failure to defend is very likely to lead to a bad faith suit. You're exposing the insured to disaster if you don't defend them. So they're quick to defend, but they may not be so quick to cover all losses. Now, there are two essential third-party coverages that associations need to get. One is a CGL policy, comprehensive general liability. Second thing they need is directors and officers liability coverage. These may come from these will be two different policies. They may come from two different companies. Who knows? They are not the same thing. And if push comes to shove, you need to be careful. Tender it to both carriers. If there's a liability claim involving directors, tender it to both carriers or under both policies. And lastly, associations need what's called a fidelity bond that insures the association against theft or embezzlement by officers or the property manager. Make sure the property manager is also covered. These things do happen. Embezzlement and theft of association funds, this does happen. Now, let's just make sure everyone's clear on the difference here. You see this little picture on the left. First party coverage for damage to the association's property. That's the property insurance policy. Over on the right, third party liability coverage that protects them against claims by others against the association. So that judgment against the association gets paid up to the policy limits and their cost of defense is covered. Third, fidelity bond. This insures the association against theft by employees. And then over here on the right, directors and officers liability policy insures everybody against mistakes. Negligent. Now, the most common things that you get here are negligence, causes of action, negligent infliction of emotional distress or some kind of a tort, something. Breach of contract, breach of fiduciary duty. This is what the D&O policy is insuring against, these such claims, and defends against them as well. So these are very important required coverages. Certain issues that you need to consider whenever you're dealing with insurance. First, you would want property insurance that provides full insurable replacement cost for the property so that it ensures that the association will have the full replacement cost of whatever is damaged. Secondly, as I said earlier, make sure that the CGL policy is all risk or special form, not named peril. Exclusions about mold, about lead, about asbestos should be read very carefully because asbestos remediation, mold remediation, for example, are very expensive. I don't know how much lead paint is still around. There's certainly some of it, but mold issues are unfortunately quite common. In older buildings, you could find lead or asbestos. Read the exclusions very carefully and make sure you have the coverage that you need. Now, if the association's property is in an area where there is flood damage, or flood risk, I should say, earthquake risk, they may need to buy a special policy that covers this. This is what insurance consultants are for. You may need, if it's a big building, a lot of responsibilities, you may want to consult with an association, risk management, or insurance consultant about what coverages you should get. Terrorism coverage, these things need to be in there. And then there's always this question of how high should the deductible be? Sometimes people, probably the most common mistake is to make the deductible too low. Because there's a risk involved in making small claims, relatively small claims. Of course, It's nice for the insurance company to cover these claims, but except for a low deductible, but your insurance rates are going to go up if you make that claim. And so in the long run, it may be cheaper to have the high deductible. There are property management companies, at least one big one that operates in this area and many other areas, that does its own insurance. I think essentially what they're doing is pooling insurance for various associations, which is perfectly legal. It's in the insurance code. I mean, it's in the Condo Act. And this is what I'm talking about here is a practice where you're essentially buying your insurance from the property management company. Now, the problem here is what happens if you fire the property management company? And you could find yourself in a position where when you fired the manager, you lose your insurance. And that's a problem. So be very careful about this. My own view of it has always been you shop for insurance. You don't trust the property manager to be providing this. Same thing with banking services, by the way. There's a property management firm that provides banking services, has its own bank. What the heck is that all about? Find your own bank. You fire the property manager, you lose your bank. Now, insurance is spelled out in the Condo Act, Section 12. And so I'm just summarizing it. It's fairly long. I'm going to go through most of it here with you just to show you what's there. Here are the sections. Section A tells you what coverages are required. Section B tells you about the property insurance that you're supposed to get. Section C talks about deductibles. D, other coverages. E talks about the very important thing, waiver of subrogation. F talks about whose policy is primary. G deals with how losses are adjusted. H talks about whether associations can mandate that unit owners get coverage. I, certificates of insurance, etc. So you can see it's quite comprehensive. Illinois law under Section 12 requires condo associations to get all three of the types of insurance I just described. Here I've kind of summarized it. There's details under subparagraphs 1, 2, and 3. Basically, no policy of insurance shall be issued or delivered, etc., unless the insurance coverage includes the following. 1, property insurance. 2, general liability insurance. 3, fidelity, bond, and D&O coverage. And it explains what the requirements are. Property insurance. The property insurance for a condo association is supposed to cover the entirety of the common elements, including limited common elements. And then it explains the concept of an airspace condominium, providing coverage for special form causes of loss, which is the way we describe sometimes all risk. And it provides coverage for full insurable replacement cost of the insured property. That's the term I used earlier. That's what you're looking for. Full insurable replacement cost, less deductibles, but including coverage sufficient to rebuild, which includes building to today's standards, because obviously that's what you'd have to do. So we have number 1, first coverage, property. Second, liability. CGL insurance against claims and liabilities arising in connection with the ownership, existence, use, or management of the property. Minimum coverage of $1 million for liability, insuring the board, the association, the corporation itself, the managing agent, and their employees and agents. If there's a developer still around, the developer has to be included. And so you see, these are the requirements. And in theory, no one would sell a condo association insurance that didn't have these characteristics, but you should be very careful that you get what you're supposed to be getting. The fidelity bond. If you have 6 or more dwelling units, you must obtain a fidelity bond that covers people, including the managing agent, anybody who controls or disperses funds of the association, for the maximum amount of coverage available to protect their funds. Now, here's the thing. As to the managing agent, It is a common practice to allow the management company to sign checks. That is, to pay the bills of the association. That's very, very common. Nothing wrong with that. As long as the only account the management company can sign on is the operating account for operating expenses. Under no circumstances should the management company have access to the reserves. And typically, that should be a two-signature account. That is, the reserve should require two signatures. But the management company should not be able to write checks on your reserves. The management company is authorized to or has standing to act in your behalf under a bond. But the point is, for these fidelity bonds, but the point is, you need to be bonded to the extent, the full amount of your association funds and reserves. This is the directors and officers coverage. The board of directors should obtain liability coverage, D&O coverage at a level deemed reasonable by the board. Now, this is not CGL. This is D&O policy. And it has to cover all their actions. And as it explains, the coverage has to include defense of non-monetary actions, torts, defense of breach of contract, and defense of decisions related to the placement or adequacy of insurance. And everyone has to be included as an insured, all past, present, and future board members, the managing agent, and our employees, etc. Now, this deals with the units here and the common elements, the requirements. The insurance, this is now the property insurance, that's A1, has to include the units, limited common elements, and the common elements. Now, down below it explains what the common elements are. Now, we're going to talk in a minute about owner policies and about which insurance is primary. But just for now, understand you have here a definition of the common elements, and this is going to be in your declaration anyway. But it's stated again here in the insurance section because it explains what has to be covered by the property insurance, which is basically the whole building. Now this comes up a lot. This is the options for paying deductibles. Let's who pays the association's deductible? As it explains, the board of directors, if there's a claim involving damage to a unit or the common elements, the board of directors can make a choice. One, they can pay the deductible as a common expense. Two, they can assess the deductible against the owners who caused the damage or who own the unit that the damage originated from. So, for example, let's say they have a water heater or a dryer, a water heater or a washing machine that leaks into a unit below. You have a notice hearing and assess the deductible against the owners who caused the damage. The association's policy pays it. The owner whose unit caused the damage pays the deductible. Or they can require the unit owners of the units that are affected, the ones the water went into, to pay the deductible. So this is a power that the board of directors has, and it's kind of delegated to them to make the decision. It's entirely up to them, which may leave certain owners dissatisfied, but that's the way it is. Some declarations require other coverages, and on these matters, the board of directors can decide to purchase workers' comp, certain types of environmental insurance, equipment policies, and other things as well. They have the power to do this as they consider appropriate. Now, this is an important one. Subrogation. Let's talk about subrogation. This is section 12E. Subrogation is when the insurance, in this context, subrogation means the insurance company would pay off a first-party claim. They would, for example, pay for let's say there was damage caused to the association's property in this example. Maybe, I don't know, a tree branch from adjoining property. There's a tree next door. It fell over, damaged the association, damaged the building. The association can pay that claim. And then the insurance company steps into the shoes of the association. Then they obtain the association's right to sue the guilty party. That's called subrogation. The insurance company steps into the shoes of the insured after they have paid the insured's claim, and then they have take over the association's liability claim against the third party who caused the damage. Another example, auto insurance company. You have car insurance. You have an accident. It's not your fault. The insurance company pays you. They fix your car, but then they are subrogated to your claim against the driver who hit you. You no longer have that claim. They have it because they paid you. Now, this can get really complicated, and so here's how the Condo Act deals with it. Waivers of subrogation. The insurance policies have all of these terms. Each unit owner and their secured party is an insured person. All the unit owners are insured persons under the policy with respect to liability that comes out of their interests in the common elements. The insurer waives its right to subrogation against the unit owners, and the unit owner waives the right to subrogation against the association. So this way the insurance company simply pays the claim, and you don't have ensuing subrogation lawsuits. So it simplifies matters. Now let's talk about primary policies. The primary policy is the one that is first in line to pay a loss up to the limits of that policy. There may be unit owner, you may have, as we just talked about, a damage, and this is with condos is very common. You may have a loss that might be covered both by the association's policy that covers the whole building and also insurance unit owner policies that cover the same property, that cover the contents of a unit. The association's policy is the primary insurance. Again, this saves a lot of trouble in litigation. It's right in the statute. The association's policy is primary. The association adjusts losses with the insurance company in the property insurance claim. So that means the association is the party with whom the insurance company is going to deal. Now, there are obviously some losses that are going to be particular to certain units. And so this can get complicated, but understand it is set up so that the association acts on behalf of all the owners, the affected owners first. And there may be adjustment and readjustment of the losses later, but the association is the one that's going to primarily be responsible. Now, damage to the personal property in the inside of units is almost certainly going to be the responsibility of the owner, unless it's caused by something that came from the common elements. So that you could have an association pipe or something part of the building that leaks into a unit, then the association is, of course, going to be responsible for the whole thing. But always view this from the standpoint of the association taking the lead with the insurance companies. Now, mentioned unit owner coverage. 12H requires or mandates that a board of directors has the power under their declaration and their bylaws or by a rule they adopt themselves. They can require the unit owners to buy insurance so that they are covered against damages that they cause to another unit. Now, this is probably advisable because it takes the burden off the association's policy as the only insurance policy around. Some other provisions, and this is a good practice, certificates of insurance. Contractors and vendors that the association hires that are doing business with the condo association must provide certificates of insurance. If the contract's over $10,000, they have to provide, upon request, a certificate of insurance naming the association, etc., as additional insured parties. This is important because one way of avoiding risk is to get contractors to do things rather than to have the association do those things themselves and potentially do them wrong and incur liability. So it's nice to have an independent contractor doing it. But always get a certificate of insurance from the contractor or vendor that makes sure the association is named as an insured. Um, uh, Non-residential condos. This refers here to commercial condominiums. And so again, the terms are different. The situation is different for commercial condominiums. So now let's address this topic of risk prevention for a few minutes. In addition to obtaining proper insurance, I think any insurance consultant will tell you that you need to take a step back before you think about insurance and think about preventing injury, preventing claims. Now, this is just a pool sign, but it's a really interesting, I think, it's an example. Note that it advises people there's no lifeguard on duty, etc., states the rules, the hours, and so forth, and tells how to do life support. I just picked this up. This is a good example of risk prevention or mitigation. So, number one, always, if it's particularly in a big association, consider getting some specific advice for your association from an insurance consultant. Think about it. Might be worth doing. Secondly, condo directors and officers should identify the people, the places, and the things on their property that are relevant to this whole issue of risk. For example, what types of people are using various parts of the property? Children, seniors, visitors, guests, owners and tenants, contractors coming on the property. Who else? Who's using the property and who's doing what? And what places and things pose identifiable risks? I gave you the first example, swimming pools. That's obviously a risk area, a swimming pool. Diving boards and pool decks where people can slip and on and on. Places where there can be broken glass and that sort of thing. Stairways. One leading case dealing with insurance liability and limits and associations dealt with someone who fell off a stair at a condo. She got her foot stuck between a stairway and the wall and took a fall backwards, and because her foot was stuck, could not break or fall in any way, suffered a severe head injury, way over the policy limits. So, be aware of these things. Hand railings, gates, windows, and decks and railings, trees, playgrounds, parking lots, construction areas. These things all need to be looked at very carefully. How do you reduce the risks? Well, the most obvious is warnings, disclaimers, signs, proper maintenance of the property and documentation of maintenance schedules. When someone says, when was the last time you inspected this or that, it would be nice if you knew. When was the last time you inspected the elevator? That sort of thing. Preventive measures, guarding against frozen pipes, fire hazards, slippery walkways, and a lot of that means education and training of the owners, because the board can't do all of this. The owners need to understand where some of these risks are and what to do about it. And you probably know this, but associations routinely advise members about matters like this if they're well run. Then you need to have a plan about what you're going to do if somebody is injured on the premises. I mean, what's the plan? What's the response plan? The board of directors ought to know about this. Anything that could lead to a claim against the association, there should be a plan for how to respond to it if it happens. And then, as I mentioned, contracting out certain responsibilities and getting the association a certificate of insurance. Some things you just don't want to do. I mean, if you're hiring, for example, a landscape maintenance company, then the landscape maintenance company is responsible for any of the problems that might result from their activities. If the association has somebody doing it, their own people doing it, there's no third-party contractor, and any claim will go directly against the association. Now, what about injury to third parties on association properties when, unfortunately, it happens? First thing to understand is protect life first, then worry about property. Render first aid. Do something to, that's why you should have a plan in place, but be in a position to render first aid to injured parties first. Worry about property later. And then report anything that might lead to a claim against the association, it should be reported as soon as possible to the insurance carrier. Don't wait. And maintain detailed records of every single thing any association person does, from the moment of the injury or the claim through the whole claims adjusting process up to the payment of the claim or denial of the claim. Take pictures, make notes, etc. And this needs to continue all the way through the claims adjusting process, because what if as we'll talk about in just a minute, what if the insurance company doesn't handle the claim the way you think they should? You need to document things. Now understand that there is a duty to cooperate with the insurance company. That is, the association, as the insured, has to cooperate, answer questions, provide documents, make themselves available, let the property be inspected, and so forth. And this is a failure to do this will excuse the insurance company from having to pay the claim. So this is serious business. The duty to cooperate with the insurance company is very important. So that was liability. Now, what about first-party claims, damage to association property? Well, how do you handle those? Number one, make sure everybody understands, residents, directors, everybody, that there's a big difference between maintenance expenses and incidents of sudden and accidental losses that are covered. Maintenance, not covered. Sudden and accidental loss may be covered. Residents have to understand this. Everybody has to understand this. Next thing is to understand that you should mitigate damages if you possibly can, prevent further damage. If there's a broken window, for example, cover it. Now, sometimes these mitigation actions might be really substantial actions that might affect the ability of the insurance carrier to repair the property the way they want to. So if it's something that seems like a big deal, that might be close to being a repair, clear that with the insurance carrier before you do it. Then we have this issue of the deductible. Remember, the association has to pay the deductible. Making a claim raises the insurance rates. So in some cases, it is better to fix it, to pay for hiring a contractor rather than making the claim. This has to be considered. If the association reports it, it's very important that the board not only document everything they're doing with the insurance company, but also that they communicate with the members about the claim as it progresses. Because if people don't know what's going on, maybe it only involves a few people, but whoever it involves, it's important to communicate. It leads to misunderstandings if you don't. Now, if they are not satisfied with the way the claim is being adjusted, there is such a thing as an independent adjuster. The association can hire an independent adjuster who will then communicate with the insurance company's adjuster. These people are usually former insurance company adjusters or executives, and they often really can be very helpful. They usually get paid on a contingency fee. In essence, they get a percentage of the loss of the damages that they recover from the association. There are circumstances where associations sue their own insurance company for denying coverage and for bad faith, and you hope that'll never happen, but it could. Now, in the case of a directors and officers or CGL claim, you may say, which is it? Don't try to make the decision. Report it under both policies. Let the insurance company or companies decide whether to treat it as a D&O or a CGL claim. Don't make that decision yourself. And then on the Fidelity bond issue, if there is what appears to be theft of association funds, see an attorney or an accountant before doing anything else. Before you make a claim under the Fidelity bond, see an attorney or see an accountant and make sure you understand what the situation is. Somebody who can help you understand whether it is likely that there was a theft or not before you go off the deep end, accuse somebody of theft, etc., and report it to the Fidelity bond. So to close, insurance is a very important asset for associations, but it's not a substitute for adequate reserves. So it doesn't cover wear and tear. It covers sudden and accidental losses, not a substitute for reserves. Certain coverages are absolutely necessary. and an association should definitely get them, and we've covered them. If you have questions or it's complicated, perhaps you should speak with an insurance specialist about this. There are lots of people who specialize in association insurance. They'll talk with you about it. Always try to minimize risks so that you don't get a claim, and try to mitigate damages, and also people need to understand how the claims process works. If necessary, and a claim is not going well, there are independent adjusters who will work with you and for you to try to negotiate the claim to a successful conclusion and hopefully prevent litigation or further disputes. And that concludes our presentation.